Hello viewers, I am Professor Sharanjeet, teaching at the Rajiv Gandhi National University of Law, Punjab. Today we shall be talking about the concept of open prisons. A nation should be judged by how it treats its lowest citizens and not by how it treats its highest ones. Dear viewers, a prison is conceived as a place with high walls, small dingy cells, restrictions and gates. Prisoners lead a life away from their family, friends and society to repent for the crime they have committed. The object of incarceration is to keep them away from the society, reform them, give justice to the victims of crime, and also to give a deterrent message to the like-minded people. The sentencing policy is not uniform in our country. Criminals demonstrating a tendency towards reformation and rehabilitation may receive a lesser sentence compared to the hardened criminals. Thus, the sentencing policy paves the way for the reformation, rehabilitation and reintegration of the offender into the society. However, when we look at the flip side of the coin, we encounter certain challenges and roadblocks. In the case of Sri Ramamurthy versus State of Karnataka, 1996, the court highlighted major challenges faced by the correctional administration in India, including overcrowding, delay in trials, torture and ill treatment during custody, neglect of health and hygiene, substandard food and inadequate clothing, prison vices, deficiency in communication, and the need for streamlining jail visits. Furthermore, the COVID-19 pandemic further highlighted these deficiencies. These challenges also strike a blow to the reformation and rehabilitation of the prisoners. The universally held view in India is that a sentence of imprisonment can be justified only if it leads to the ultimate protection of the society against the crime. Thus, the objective of incarceration is not merely to keep the offender away from the society, but also to motivate the offender to become a law-abiding and self-supporting person. There is no denying the fact that imprisonment deprives the offender of his liberty, and many times the prison system may also aggravate the sufferings already inherent in the process of incarceration. It is felt that certain categories of offenders who have committed petty offences or who do not indulge in offences against the state like terrorism and organized crimes like human trafficking, peddling of commercial quantities of drugs, and smuggling of arms and ammunition can be segregated and given the advantage of staying in an open prison. The reformatory aspect of incarceration has also been highlighted by the 1977 International Covenant on Civil and Political Rights, to which India is a party, where it was stated that the imprisonment system or sentencing system shall comprise treatment of prisoners, the essential aim of which shall be their reformation and social rehabilitation. Similarly, the prison administration in India has been subjected to intense review by the higher judiciary, and the courts have emphasized that prisoners have to be reformed through dignified treatment. The United Nations Standard Minimum Rules for the treatment of prisoners, popularly known as the Nelson Mandela Rules, are also points of reference for states in developing standards for the treatment of the prisoners. By adopting the Nelson Mandela Rules in 2015, the United Nations General Assembly aims to guide the states in the effective management of prisons and prevent torture and ill treatment of the vulnerable inmates. Dear viewers, these international instruments also very pertinently aim towards preventing recidivism or relapsing into crime. Open prisons can help alleviate some of the aforementioned problems. Open prisons, in contrast to the regular prisons, are more reformatory in nature. The open prison model, successfully followed worldwide, particularly in the Indian context in the states of Rajasthan, can help navigate through some of these challenges. Now the question arises, what is an open prison? An open prison is a prison with a minimum of restrictions on the prisoner's movements and activities. Prisoners in such prisons can engage in employment or agricultural related work, animal husbandry, or work in cottage industries while serving their sentence. They are also allowed to live with their families. As per the Rajasthan prison rules, open prisons are prisons without walls, bars, and locks. Traditional prisons reflect a restrictive environment with high walls and fences. On the contrary, an open prison presents an altogether different picture of some hope. As the very name suggests, open prisons refers to a prison with the fewest restrictions on the inmates. The concept of open prisons is very well in tune with the international standards for the treatment of the prisoners. There is no denying the fact that our country, India, shares the universal view that a sentence of imprisonment would be justifiable only if it ultimately leads to the protection of the society against the crime. Such a goal could be achieved only if incarceration helps the offender become a law-abiding and self-supporting citizen after his release from the prison. Open jails can work wonders in this regard because in open jails, the prisoner is allowed to live with the family, pursue employment, or engage in agricultural activities, which helps him to reform in a better way. However, the prisoners to be sent to the open jails have to be carefully selected by a committee formulated in this regard. Now we shall be talking about the objectives of open prisons. Throughout the world, open prisons are considered to be very suitable for progressive correctional administration due to the primary reason that they help the prisoner maintain contact with the society while undergoing the sentence. Open prisons can also help prevent recidivism and keep the society safe from criminals and criminality. Another objective of open prisons is to prevent idleness within the prison structures, keeping the prisoners physically and mentally fit, and also help in preventing mental disorders and diseases. Open prisons are an integral part of prison reforms in India. The objective is also to engage the prisoner at public utility construction sites. As Justice Krishna Iyer had rightly observed, society must strongly condemn crime through punishment, but brutal deterrence is a fiendish folly and is a kind of crime by punishment. It frightens, never refines. It wounds, but never heals. Here, prisons play an important role in the reformation of the prisoner. Open prisons represent one of the most successful applications of the principle of individualization of punishments with a view to social adjustments. Furthermore, one can also perceive them from the perspective of transformative punishment. Open institutions are far less costly than the jail establishments. They have the further advantage that the government is able to employ a large number of prisoners in prison which would otherwise remain idle and unproductive. Now we shall be focusing on the key features of the open prisons. In open prisons, there is a minimum restriction on the inmates. Open prisons offers an opportunity for transformative punishment for the inmates. Open prisons help with better social interaction among the inmates and subsequent readjustment post-incarceration. The stigma and shame associated with incarceration also gradually fades away. Prisoners can leave the prison for work and must return to the prison campus after their working hours each day. In the Indian context, with regards to open prisons, the prisoners usually work in farming, animal husbandry, and cottage industries. In India, as we all know, prisons are a state subject, and hence different states have devised different mechanisms with regards to the open prisons. The state governments have different parameters with regards to the selection of the prisoners for open prisons. Sometimes, prisoners convicted of crimes against the state, such as collection of arms, sedation, contract killing, sexual offences, may be deemed ineligible for the open prisons. Prisoners who are considered dangerous, prisoners convicted for offences such as terrorism, insurgency, Naxalism, kidnapping for ransom, smuggling, including those convicted under the Narcotic Drugs and Psychotropic Substances Act, members of organized criminal gangs, prisoners convicted for failure to provide security for maintaining peace and good behavior, prisoners suffering from mental illness, and prisoners whose transfer is likely to have repercussions elsewhere in the country may not be selected for transfer to the open prisons. In almost all the states, there is a common requirement that before being transferred to an open prison, the prisoner must have spent some time in the normal jail and his behavior be disciplined and good. The classification committees of different states thoroughly screens the cases of each convicted prisoner to be considered for the purpose of transfer to an open prison on the following points before recommending them for transfer to an open institution. First, physical fitness and mental health required for living in an open institution. Second, the behavior and conduct of the prisoner. And lastly, progress in the workplace, training and education, group adjustability, character, self-discipline, and extent of institutional impact. Whether the inmate is getting institutionalized and has a sense of responsibility is also taken into account. The maximum number of open prisons in India are in Rajasthan. During the COVID-19 pandemic outbreak, authorities believed that open prisons offered a more effective approach to addressing the pandemic situation and preventing the spread of the deadly virus. Certain categories of offenders who indulge in crimes affecting public safety and requiring segregation from mainstream society through imprisonment may not find the mechanism of open prisons suitable. However, with regards to the other prisoners who still have social and family ties, open prisons can be a very useful mode of correctional administration. The concept of open prisons is in tune with a large number of judgments on various aspects of prison administration, wherein the judiciary has laid down important principles like that a person on his or her conviction for a crime does not become a non-person. Secondly, The limitations of imprisonment should not infringe upon a person's entitlements to all human rights. There is no justification for aggravating the suffering already inherent in the process of incarceration. The above-mentioned principles have serious implications for prison administration across our country, and they call for restructuring of the prison system in terms of humanization of prison conditions, minimum standards for institutional care, reorientation of the prison staff, and rationalization of the prison rules and regulations. An open prison can work wonders in ensuring the best protection of prisoners' human rights and dignity. Now we shall discuss the judicial perspective on the open prisons in India. Dear listeners, in the case of Dharamveer versus State of Uttar Pradesh, 1979, the Supreme Court rightly observed that open prisons have advantages in protecting young offenders from several vices that they can grip in closed jails. Similarly, in the case of Ramamurthy versus State of Karnataka, 1997, Supreme Court observed that open prisons represent one of the most successful applications of the principles of individualization of penalties with a view towards the social adjustment of the prisoner. The Supreme Court ordered the state governments to establish more and more open jails, starting with the country's district headquarters. The Supreme Court took note of the management problems that would come with open prisons, but observed that they are not so much in the light of the greater good these prisons can provide, not only to the convicted prisoners, but to the society at large. In a 2023 case of Sardar son of Shah Wali Khan versus State of Maharashtra, the petitioner was a convict sentenced to life imprisonment under the Terrorist and Disruptive Activities Prevention Act and Section 120B of the Indian Penal Code 1860. He sought transfer to an open prison under the provisions of the Maharashtra Open Prison Rules of 1971. The selection committee had unanimously decided not to recommend his case for such a transfer to the open prison. The petitioner was a life convict in the Mumbai bomb blasts of 1993. The assistant public prosecutor had strongly opposed this petition, arguing that prisoners do not have an inherent right to be shifted to a confinement in an open prison. Considering the category of prisoners mentioned in the Maharashtra state government rules on this matter, convicts under terrorism-related offences could be said to be excluded from the benefit of selection for transfer in an open prison. The Supreme Court thus dismissed the said petition. Now we shall focus on the advantages of the open prisons. It is interesting to note that the open prisons are a reminder of the Gandhian ashrams, where the emphasis was on shared community living for the development of moral character, which in turn has a greater affirmative potential for the individual. Therefore, open prisons are considered more suitable for prisoners who have family ties. The state incurs a significantly higher expenditure on conventional jails compared to the open prisons. Open prisons are also suitable in the Indian context to reduce the overcrowding in the jails. In 2024, if we have to identify the most prominent problem or challenge to correctional administration, that is in fact overcrowding. Open prisons are more in tune with the reformation of criminals because they do not have an adverse impact on the mental health of the prisoners. the likelihood of relapsing into crime is also significantly diminished. The prisoners are able to adjust to the environment better because through the mechanism of open jails, they are already in gainful employment and their societal ties are also kept intact. Furthermore, certain open prisons allow prisoners to live with their families and attend to the family needs as and when required. Now we shall talk about the problems associated with the open jails. The flip side of this aspect may pose some serious challenges. There can be problems with regards to selecting the prisoners for the open prison system. How to determine the suitability of a prisoner for open jails can pose serious challenges. Prisoners shifted to open prisons have been observed to refuse to vacate the premises after completing their sentences. At times, difficulties are also faced in procuring employment opportunities in the vicinity of the open prisons. Due to the paucity of infrastructure in open prisons, many times the families are unable to live with the prisoner. Many people believe that open prisons are not suitable for habitual and hardened criminals who have no respect for the legal system and commits crime with impunity. The convicted prisoners are eligible to live in the open prisons, while under trials are not permitted to live in the open prisons. Open prisons often require a large amount of space, which can be challenging to find near cities, making the mechanism impractical. Furthermore, poverty and illiteracy exacerbate this problem by leading to people being incarcerated due to their lack of knowledge about the law. Poverty aggravates the problem. More recently, in 2017, the Supreme Court asked the states to establish an open prison in each district. The open prison system can successfully accommodate female prisoners, old and infirm prisoners, people who are not habitual criminals, first-time offenders, and petty criminals. According to the National Crime Record Bureau, as of December 31st, 2021, open jails in West Bengal accommodated 49 male convicts. A total of 2153 convicts, including 209 males and 59 females, were accommodated in 88 open jails across the country. To conclude, the state government should frame detailed rules regarding the administration of open prison institutions, set up more open training institutions and open colonies. Each state should fix the administration details of open institutions in accordance with the local conditions. Each state should prioritize work, literacy projects, social education, training in agriculture and allied fields, and cultural activities. The inmates should be allowed to bring their family members to the open colony, where other family members should be given opportunities to work in agriculture, cottage industry, or other suitable means of livelihood as can be conveniently organized. Work programs in the colony should be organized on a corporate basis. The state should prescribe wages for inmates and their family members who work in the colonies. Efforts should be made to gradually release inmates from the closed conditions of prisons, enabling their transfers to an open institution at the final stage. Prisoners who fail to meet the standards of discipline in these camps should be transferred back to the closed institutions. With this, we come to an end of today's lecture. Thank you very much.